As far as I know, with this new technology, we are on live now. We are live. So I wanted to thank my two guests that I have, David Hoffman and Debbie Champion. Thanks for coming on today.
Thank you, Gary.
Thanks, Gary.
So, so this is a combination. We're bringing together a lot of worlds right now because this is Debbie Champion and I have done a podcast, 40 or 50 episodes now called Lawyer v. Lawyer, where she and I do podcasts, and we're going to do a podcast today. But I said, hey, let's bring in the worlds of podcasting and Facebook Live and do this today. Meanwhile, we also had our friend Dave Hoffman wanted to be, just kind of reached out to us and said, hey guys, I'm friends with both you guys independently. Let's talk. And so we were excited to have him. So that's just a little bit of a way of introduction. So let's get going. So Debbie, I have a question for you.
Okay.
Tell me, how did you meet Dave? How do you know Dave?
Well, he's going to tell you a little bit about what he's doing right now, but before Dave's current job, he worked at a firm in St. Louis, and we had a number of cases together. We did have some memorable cases together that were fun for us and not so much fun for other people, but that may be all Dave lets me tell.
Yeah, I think maybe we'll leave it at that. Yeah.
So, all right, great. So, Dave, how do you and I know each other?
Well, we've worked on opposite sides of the fence on various personal injury cases over the years before I switched to my new role as a claims handler for an insurance company here in the Midwest. And so that's how we got to know each other, is through cases together, some small, some big. And I've been following you and Debbie online through your various podcasts and different media enterprises, and been learning a lot through the present time from you guys. So I appreciate everything that you guys have been bringing to the legal community as well.
Right. So, so people sometimes ask and talk to lawyers. We do this. We talk about lawyers a lot, what they do. It's interesting because, Dave, you were had a successful litigation practice for years, and now you've done a change in your career. And in either whether you're a lawyer or whether you're a layman or something, people don't know the different roles lawyers can play. So you can explain the transition that you made about 2 years ago and why you did it?
Yeah, 2 years ago, I switched over to RLI Insurance based in Peoria, Illinois. I joined their casualty claims team. I always enjoy interacting with claims handlers and adjusters on my files as an insurance defense lawyer for 16 years here in the St. Louis area. I always enjoyed working with them on the pre-suit investigations and helping the claims adjusters, figure out where a case might head if and when it goes to litigation, and what they can do to minimize their risks up front. And it was so interesting to me that I thought, hey, not true. It's been going quite well for the last 2 years. Can you guys hear me? I'm so sorry.
Yeah, that's okay.
Yeah, I had a phone call come in and my screen froze up here, but I've been doing it for the last 2 years. And the reason for the change was really for more time with my family, a little bit less travel, and just to try something new out. And it turns out I love it. It's been a really great transition for me.
Dave, how old are your kids?
I have a 6.5-year-old, and then I have a 13-year-old who's going to be bar mitzvah this October.
Oh, fun!
That's fun. Because I was, so Debbie and I did a podcast with another. We've done podcasts with different female lawyers and talking about work-life balance, but I've also friends with you in Facebook, and I see what a devoted father you are. So we did a short pre-meeting, and I don't want to put you on the spot, but what's it like? We talk about women and balancing work-life, family stuff. I have 4 kids. I spend a lot of time with my family. What's it like as a dad being a lawyer too? Tell me, what's your experience?
Um, Being a lawyer as a father, it is challenging. You know, but what I've learned to do over time is uh, set aside a rigorous schedule each day, what time I'm going to have with my kids versus time with work. And then I always save time at the end of the day after my kids go to bed to follow up on those emails that may trickle in at 5 and 6 o'clock. So for me, the way that I've handled being a parent and a lawyer over the years, and I've gotten a little bit better at it, is to really stick to a rigorous schedule. And that way you give nobility to your kids, to your other family members as well, and kind of set expectations in that regard.
Dave, did you say you give nobility to your kids?
I give my kids no ability in terms of my
No,
schedule.
I like that.
No
I like that
ability.
you're putting them at that. That's
Yes.
good.
So,
Yeah,
you got
you
to
know that's
manage expectations.
one of the things that I valued, and I get as I do it longer, I value more the kind of firm that I have is my ability to, to be with my kids when I want and stuff too. So like I today I took my kid, I have a 2-year-old. I took my 2-year-old to a 10 o'clock doctor's visit while I had recorded some CLEs for the solo and small firm conference. They're playing, and I'm moderating that, and I'm also doing stuff. So and I do the late night emails to you, like Dave, as you do, Dave, and stuff too. So it's we gotta as you go on in life, you gotta make sure that your work makes room for your family and vice versa.
I think that's very true. And it's just really important as you get older, I think, and you may know this a little bit better than me, Gary, because you're a couple years older than me, but
Boom.
you, yeah, in a good way. I think over time, you learn that you only have one life to live, and you only have so much time with your kids, and before you know it, they're out of the house. And I mean, I started my practice when my son Noah was just a little tight, and he's already now in junior high, and it just makes you realize that you only have so much time with your kids too, and so you want to put your best foot forward, both as a parent and then especially as a father and mother as well. And I think it's taken me a little bit of time to figure that out, but I've been able and fortunate to figure that out on my own. I also think it's really important. You have to figure it out as yourself, as an individual, and which means making mistakes here and there and learning from those mistakes. And part of that, for example, I've missed some things at school, and then I kind of kick myself in the butt afterwards, thinking, man, I shouldn't have missed that. So it's just knowing what's on your schedule, keeping to the schedule, and making time for the most important things in your life.
Debbie, so I've asked this, and Debbie's answer on work-life balance is great. Debbie, what's your answer on work and home life balance?
I think what you're probably going to say is I say it does not exist in my life.
That's what you always say. You say, I don't got it.
I don't. I'm the first to admit it. I do not have it because I'm happily married, but I don't have any kids except for the ones who work for me here, who are all from age 30 to 60. But I am troubled by the fact that I don't have that. But I really do feel like I've got to, I got to make some rain for all these people here. I have to put food on their plate. So I've gotten myself kind of in a bad situation where I still have a lot of fun. I still do a lot of fun stuff, but I work too much.
What questions you got for Dave, Debbie? I've been shooting some at him. Do you have any, or do you want me to jump into some? We have questions coming in from the
I
Facebook.
know. I see all these great questions over here. Some of them are making me laugh, and then some of them are making me want to jump into those, except that I think Dave should talk about the difference in how working in the claims area versus working in the litigation area, how his working as a lawyer helped you help your company?
Well, the perspective as a litigator has really given me insight in terms of budgeting on a file, what's realistic.
Yeah.
I also have a really, now that I'm kind of behind the curtain, so to speak, I have a better idea of what estimates on files really mean. Sometimes you can take them with a grain of salt, certainly. But for me, it was, at Sandberg Phoenix, I garnered so many tools in terms of investigation and pre-suit handling, and those skills have really helped me be, I think, a pretty good claims handler.
And so, Dave, as how has your view or attitude towards cases changed, if at all, in your role as a claims representative?
I don't know if they've changed that much, but I guess I'm able to step back a little bit more now and realize that I have a good understanding of it's not the greatest idea to try a case. It's dangerous for all parties involved, and that's something that I've learned over time. And I've gained a greater appreciation for having a plan of action leading up to a sentinel negotiation point in a file, and really not wasting that opportunity that it may be your only opportunity to speak or to introduce yourselves and to get to know the plaintiffs or the other side in a case. So I think that's the perspective that I gained.
Well, Dave's toting a lot of that party line. We've got to have him on for some podcast, Gary, because I want to delve a little deeper into some of this stuff.
Right. One of the things I've talked about is that on the plaintiff side, I have to, and I do communicate how much I'm going to do great for them and get a great result and on all that. But at the same time, I also have to tell them that there are risks attendant to the case, like losing a trial, losing a significant motion, that there is a risk of loss. And then the balance I have is, while I'm trying to say that, I don't want my client to think I'm speaking out of both sides of my mouth.
Mm-hmm.
Sometimes mediators are good at conveying that, but that they're really, you can go look and see all the $1 million verdicts. I put them on my website or wherever else you get them, right? But there's also zeros out there. And so, okay, Dave, and I just a question for you. You try to get the zero. Ultimately, now you try to get you often have to good faith, fairly adjust a claim, obviously, but at the same time, it's a competitive deal. So what are your thoughts on that from the claim side?
Well, I think that in terms of evaluating a claim, our goal is to compensate for what's just and fair. I think the line is not a penny more, not a penny less. And so that's what I'm always trying to do, is find that balance. We really, I don't think it's fair to say that we're looking for zeros. We're looking for what's fair and just compensation, because in the end, we are trying to, minimize. As much as we like paying people like Debbie, we're also looking for resolution and knowability, not nobility, but knowability, Debbie, in terms of how much a file is worth. So, that's what we're really looking at.
And it really is a different perspective, because not that I necessarily always want to get zeros, because you do want the right thing to happen, whatever the right thing would be. But I don't concern myself as much with the economics as a whole. I concern myself more with the economics of the claim. And Dave's job is much broader than mine. He has to think about the entire risk to the company who's insuring the insured. He has to think about how much the bottom line is on the budget. How much is it going to cost him to pay me to try the case? So it's really a different perspective.
Yeah, and we all have to, those three of us, our roles. For people who aren't familiar, I'm a plaintiff's lawyer. Debbie mostly represents defendants, and Dave is the represents an insurer where a company spreads the risk, people pay premiums, and he adjusts those claims or assists it. But Dave has a long history of litigation practice as well before that. And many of the people watching this, like in the general community too, it's not just injured people who watch that. People get sued. And when you're a defendant and you're getting sued because something happened, you want to know that you have, Dave you work with the insureds all the time when people make a claim against you, and Debbie, you represent them. I picked a lot of juries. Every time you pick a jury, and you guys have too, you say who's ever made a claim, but who's ever been sued? And people have very personal experiences about when they've been sued. So, Dave, tell me when you're representing or helping out an insured, how do you look at that partnership?
I look at it as a relationship where we're trying to gain as much inside information about the claim as possible from the insured, and it's about keeping the lines of communication open. It's about knowing to ask the right questions. A lot of times, the insureds aren't as sophisticated as us, and they may not know the information that they have. So I feel like it's very important. Actually, the number one thing that we do on day one is we initiate contact. We want to build a rapport early on so that we can work with the insured to get the necessary information. And that is job number one, is initiate that contact, get that relationship going, so that even in a situation where there may not end up being coverage, we've established a line of communication so that we can properly and effectively communicate that to them, and sometimes let them know that, hey, you need to hire outside counsel to help you in this situation, because if and when suits filed, it's not going to be a covered matter, and it's not something that sometimes there's situations where we may not even have a duty to defend. So it's very important early on to get that line of communication going so that when you have those tougher conversations later on, that you've already built those steps to have those discussions so that the information can be effectively passed along to the insured and also digested by the insured.
Right, that's the key.
All right. So let me do some of our. Well, here I had a question for you. Have you? How do you measure, or how do you deal with the finality of either a judgment or a summary judgment issue? Because we could talk about I can go try a case and try to get a big verdict, and if I win a case, Debbie, your insured is hit with a judgment, and the insurance company has to pay. Similarly, if I try to push a case and I don't listen to the facts and I lose it, or I get summary judgment against me. So talk about the finality of that. And Dave, you had an interesting story from this week on that very issue. I don't know if you want to share that or not.
I'll let Debbie jump in here, and then I'll share my story for sure.
All right, go ahead, Deb.
I want to share your story. All right, so Gary, you're asking us essentially, how do we deal with the finality of something? Are you talking about settling or?
No, a judgment, because we can talk about settling stuff, but then when you go to trial or you go to summary judgment, a lot of times it's all or nothing. Now, there can be compromised verdicts, but what if it's an all or nothing deal? And how do you balance settling versus going all the way to trial? Either you're going to get a big plaintiff's verdict, or I'm going to get a big plaintiff's verdict, or you're going to get a defense verdict, something like that. Because we told a story, Debbie, about you getting a big defense verdict last year.
So I know what you're talking about now. That's really the hardest thing, where you have a case where it's all, and the all is big, or it's nothing, and there's nothing in between. Those are the hardest cases to evaluate, and people would say, well, but don't you just pick a number in between? And no, you don't just pick a number in between, because even though it's an all or nothing case, there could be more risk on the zero than there is on the all. In other words, yeah, I could win it, but my chances of winning it are 10%. So you're going to give it something in the middle? Heck no, Gary Berger's not going to take that. So you have to weigh not just the risk, not just the all or nothing risk, but the risk of each one of those two things. And that's what's hard to predict, even if you've been doing this for years and years and years and years. That's what's hard. And particularly when there's a motion for summary judgment, because that depends on how well you did on setting forth your record, whether or not the judge is going to consider certain facts to be material that you didn't think were material, whether or not the other side controverted it appropriately, and even if everything was done perfectly and you know you deserve summary judgment, whether the judge is going to grant it. And sometimes they surprisingly grant it.
Before I turn to Dave, Debbie, how do you, if Dave's the insurance company, how do you tell Dave? How do you communicate to the decision maker like Dave those issues? Because there's a lot of variables. How do you
Yeah.
how do you set it out for him so he can be a teammate with you in making a decision?
Step one for me is setting aside any liability issues. What are the damages in this case? If this were a great case, what are the damages? What is the value of a case where a 33-year-old female loses her leg? That's the first thing you got to go. So they know, worst case scenario, what am I going to get hit with? And what's the value of this on average for most cases? And then you got to think about what are things that are going to expand that value. Are there any bad acts involved other than just simple negligence? And then you want to look at the flow side. These are the things that I think count against that verdict. One is we weren't the ones who did it, or we weren't the ones that caused it, or even the accident itself, whatever that accident might be, product, whatever, isn't what caused her to lose her leg. She had diabetes and had already lost her foot, and so now she's lost the rest of it. Well, that has nothing to do with the accident that occurred. So you're talking about both of those things, and you want to give them a few different numbers. One is, here's how much the damages are. This is what our injuries were. If we caused it, it's worth this. If we didn't cause it, it's worth this. And if in things in between that you think affect risk. That's how I set it out.
What about venue? How important is venue, Debbie?
It depends on where it is, because in some states, venue doesn't matter. Anywhere in that state is great for a defendant. Like, for example, I don't know, Kansas. But if you're in Missouri, venue could be very, very important. And if you're in other states, Texas, Florida, Louisiana, you can have a dramatically different value on that case depending on where it is. Sometimes 7 to 10 times more in one county than it would be in another county.
Dave, question to you, the finality of a trial or a summary judgment or something like that, and how you balance those in risk and evaluating and resolving cases.
Well, what we like to do is early up front, we like to know from our outside counsel when a suit has been filed or litigation is immediately on the horizon. We want to know, is there in fact a true silver bullet motion for summary judgment that can be filed on behalf of our insured, and what are the chances of success? And so we take that into account, certainly, and we make no bones about it. It's not always easy to win summary judgment motion, but there are cases where it is quite appropriate, and the more technical the legal argument, the better chance that we have of success. And what I always like to do on my file is, if we truly do have a silver bullet motion, get it on file before mediation, but not the day before mediation. Let the opponents know where you're going so that there's no surprises going into the mediation. That's the best way to create leverage. And also, it's the best way for somebody like you, Gary, to be able to explain to your client and to have the time to explain to your client the risks and benefits. So, I don't like to blindside people before mediation with a summary judgment motion the night before. It almost takes away from the strength of your summary judgment motion by doing that. So those are the considerations that I take into account. We don't like to try a lot of cases.
Tell me, would you share this story from this week in general terms?
Yeah, this week I had a mediation somewhere east of the Mississippi, where we had a summary judgment motion on file, and we were told by the mediator that we didn't have basically a chance in heck of prevailing on the motion. We mediated throughout the day. I came up to a number pretty close to my authority to resolve the case. The other side was not taking it, and the mediator, a retired judge who actually was familiar with the judge at issue in the case, told us, there's no way you're going to win it. There's no way you're going to win it. And he kept trying to push us all day long. And right as the mediation, I thought, was about to fall apart and the parties were going to have to go their separate ways and perhaps get ready for trial, an order came through from the judge granting a summary judgment motion, and we immediately pulled our offer off the table and now we're talking about, well, what's it worth to avoid an appeal? That's a lucky situation that doesn't usually happen, but I did have the fortunate chance to experience that yesterday. It was quite a high for at least an hour.
Amazing.
Yeah, it was lucky, and we don't always count on that, but yeah, it happened to work out for us there.
That's amazing. Well, just go ahead, Debbie.
I just said
Debbie, has that ever happened to you?
it has happened to me, but it was in an employment case, which, as you know, is a much easier thing to try to settle. To try to get summary judgment on, because it was before you could file in state court. So it was a federal court employment case, and a lot of those cases back in the day got summary judgment on them. And we happened also to be in a long mediation, and we got summary judgment. Not as late as you did, Dave. I don't think we worked that hard for that long, but that was. I think, funny enough, in that case, I think we went on to settle it. Actually, settled rather than go through an appeal.
Well, because there's appeal of summary judgment too. You got to keep it on appeal. There's risk.
And that's certainly something that we're taking into account right now, and trying to, because we, as much as I love my defense lawyers and the success that we had yesterday, to fight an appeal, we're looking at another potentially $20,000 or so, and so you have to take that all into account in your calculus. I think it's also important. I think we were talking about this offline. You can't get too high about the victories, and you can't get too low about some of the negative outcomes that you have on any of your files. I think as a plaintiff's lawyer, as a defense lawyer, as an adjuster, you're going to have thousands of more down the road. So, you got to take them all with a grain of salt, certainly.
It's the funny thing, listening to you guys talk, I learned the same lessons on the plaintiff side. My first mentor said, don't get too high on the highs or too low on the lows in this business. I have a case where the defendant got to the Missouri Supreme Court based on a district court case out of Nevada, and a case that I have pending now. I'm waiting for an opinion. And then by the time I filed my responsive brief, the 10th Circuit had reversed and did a great case for me. And so a lot of my brief was, remember this case they thought was great? Well,
that's so great.
I couldn't hammer it home too much because it can go the other way. And so you can't jump, you can't ride that too much or say, oh, blah, And similarly, 2 years ago, I had the second big plaintiff's verdict in Missouri, but I also got defensed on the fifth best defense verdict against me. I lost a case. So that finality of judgment is, you can be on, as Dave, as you correctly said, with your many, many years of wisdom. I'm a little more gray than you still, but it is, you can be on the good side of that. You can be on the other side of that too. It goes both ways. So you gotta temper that a little bit. So good stuff. Let me do this. Any other questions, Debbie? Do you have a question now, or can I go to some of our panel questions?
Yeah, we're here to answer questions. Let's answer some of those questions.
So here, the first question is for Debbie. Debbie, what do you do if your landlord is dripping water all over your car?
I know. That's a joke, don't you?
No, is that Bob?
It's Bob Guller who sent that. And during this, I got a note.
I'm going to interrupt you. Dave, did you go to high school with Bob?
I went to Parkway North.
All right, never mind. He's at Parkway Central. All right, never mind. So go ahead, Debbie.
So I'm in the garage in this building. Gary and I happen to be in the same building. And I got a note passed to me that I needed to go move my car because there was something dripping water on it. I'm like, yeah, I don't have time to do that. Just leave it. It'll be all right. It's water. It'll probably help it. So that's why you asked me what you did when water was dripping on your car. I just ignore it.
That's funny. I got a question here. Here's a question from Kelly. Kelly asks, this question is for all of you. In one word, give the most important trait you personally think a lawyer of any type must have.
for me, it's got to be perseverance. You're going to have challenges day in, day out, from dawn till dusk. So you just have to stick to it, stick to your guns, trust yourself, and press on. So perseverance.
Debbie?
So that's interesting that Dave came up with that, because I thought you both would say, and I don't want to step on your toe, Gary. Well, let me ask you yours first.
No, I already asked. See, nice lawyer.
Okay.
There's a reason why she's an amazing. You know what Debbie does, Dave? Debbie, she goes into these trials, and she's just this Southern belle, and then she just sticks that knife in you before you know what's coming. I will go first. I had 2 words, and I wasn't sure which. I was going to go with one if you didn't go the other one.
Okay.
So I'll go with. If I have to choose one, I'm going to say serenity, and it's like a little bit what Dave said, but in this business, I say the serenity prayer. You got to know what you can control, know what you can't control, and then be sanguine and surrender to that. Because I remember when I was a puppy lawyer, I'd just be tilting at windmills, fighting in facts, and the facts are what they are. You know, if you got a case that goes south, I have these cases, and then the experts come and you didn't see something, they go south. You got to deal with it. Or I have cases where I go in and I take a great depo of a defendant and I seal the deal on liability, because that's my job. When I go take a depo of a defendant, when I go into a depo, I'm there to win the case on liability. I don't want to get his general background. I don't want to find out, what kind of training he had. I mean, I do ask those questions, but my job is to seal the deal to win the case. So serenity and knowing what I can control, and sometimes I have good days with that. Sometimes I still have to remind myself remind myself to get that clarity of serenity. So to have it do long term, and that also means anyway, that's my word, serenity. Sorry for the line.
I agree with you on that point about not being able to control the facts. I think that it is essential, no matter what kind of law you practice or what kind of insurance work you may handle. Your job is to know what the facts are and to dig down and figure out what everything is, to make your best case. But at the end of the day, if the facts aren't there on a point, it is what it is. There it is.
One of my clients bought me that. I would say this so much. One of my clients bought me a sign that said that. I have it on my desk. All right, Debbie, what's your word?
Okay, so I thought one of you guys were going to say integrity, because I think we all immediately, I knew it would be because we all are always very cognizant of our reputations, and we know if you don't have integrity in this business, then you don't have anything. So maybe that's just a given, but I thought nobody would say this, and really Dave and I got very close, and I put stamina, because I have seen so many times people give up on cases, and that's fine if it's your case, and you're a plaintiff, or a defendant, and you decide I'm going to give up on this case. But it's not fine when you have hunted down a lawyer and you have found a lawyer to represent you, and that person gives up on that case, whether it's a criminal case or a family law case. You have got to continue on, not for yourself maybe, but for your client. And if you don't like what you're doing, and you can't move the case forward because you're not willing to work on it hard enough, you don't need to be doing what we're doing. I almost said what we be doing. But
good answer.
So that's my thought. But Gary, with serenity, I will give one exception to that, and that is this. We have to keep in mind that all of us zen in different ways. And I had learned that my best serenity comes when I am calm, but I'm surrounded by chaos. When I have a lot of balls in the air and things going on, I will sometimes think to myself, I don't know when I have felt this happy. I don't know when I've been this happy. And my husband will look at me and say, oh my gosh, the world is falling apart around you, and you're like, I'm so happy. But,
I'm the same. I got so much stuff going on. It's crazy, whether it's running a firm, marketing, kids, family, all the work, all the cases I have. It's just crazy, but I'm pretty serene with that. I've learned when you're first starting out as a lawyer, it's hard to task load like that. So I'm a scuba diver. We do task loading. You do more and more stuff the more and more you get trained. So like what you could handle, like Dave, when you started as a defense lawyer, you got 10 cases. By the time you leave San Bernardino, Phoenix, you got 100. So, you learn, and then that becomes normal for you.
Exactly. Exactly. And now I've got 180 to 200, and then I'm managing 2 direct reports. So over time, you just learn to ride the waves.
Exactly.
And you're going to know that when you look at your email box, it might have 162 emails, but you figure it out, and you got to accept it. And actually, once you accept it, I think you can enjoy it a little bit more. And then that also ties into what I talked about before, which is the work-life balance and being able to know that, hey, it's 6 o'clock. It's time to go to the swim. You know what I mean?
Right.
I can come right back here at 7:30 and pick up right where I left off.
Well, Corona now, I get it all done at home too. Let me ask a new question. Maya, I like this question. I'm jumping around a little bit on the feed. Is there natural animosity between defense lawyers and plaintiffs lawyers or prosecuting, or do you get along? Are Gary and David frenemies? David?
We are friends. We are not frenemies, and that's just not how it is. Because if you approach it like the other side is your enemy, then you're not going to achieve a good result for your client in the end. Because most cases are resolved by compromise, and we've been toe to toe. There's no doubt about it. But no, you have got to have a good relationship, just in the legal community in general and with your peers. At the same time, it is crucial that I think when I was practicing it as an attorney, you don't want to be all chummy with your opponent in front of your client, because that doesn't go over well either. So there's a respect and an air of dignity that opponents must have. You cannot be. We are not frenemies. We are good friends, for goodness sake.
Debbie, your answer. What's your?
I think there are a handful of people who are in this community who try to be asses, who are pretty much everybody's enemy. So I do think there are enemies out there, but I think those enemies are purposeful. They are not there because it's part of our job. You know what I mean? It's just that in life, you're going to have people you don't like. And that's the same way in practice of law. There are just going to be people you don't like. And the reason it's so easy for lawyers to make enemies of each other is because you have that duty to advocate for your client. And it's a very emotional thing, particularly when you're younger. Remember how many fights you would have when you were younger with people? Probably many more than now. And I remember being in front of a city judge, going out to trial, with a person on the other side who is one of the best friends I have in my life. I would trust him with my life. So we were fighting on a motion in limine before trial, a motion, and I just knew I was right on it, and I was not going to win it in front of the judge, and I was fighting, and all of a sudden I feel this little hand sneak behind me and pat me on the back a little. he's like trying to calm me down because I was so mad. And I remember laughing about that, thinking, this is why lawyers get mad at each other, because you are so emotional when you think you should win something and you don't win it. Usually you're really wrong, and that's why you don't win it. But still, you believe in your client's case, and it's hard sometimes to learn to set that aside. We've all learned to set that aside, but it's hard at first.
So are there lawyers that that what, no matter what I do, this lawyer is going to be a fight? I mean, there's lawyers have reputation, just like Dave said a while ago, your reputation. Because I know, anyway, because there's some lawyers where you know what, you can be nice, but that guy's going to be a jerk. So why waste your time, or that woman, either way.
Yep.
So last week I was in a fight with another lawyer, and it was a discovery dispute, and I've had all these calls, and it's maybe a big case, and man, and he got so, and I've never had a case with this lawyer. He got, in his response, he thought I was being so fair and so pushy, and I could be pushy, stop smiling. But you gotta, hey, it is what it is. But rather than me getting mad at him, I listened to him, and I calmed myself down, and I literally, after an hour and a half, I stopped and I said, listen, I'm going to extend an olive branch. because you're right. Because I usually get along with other lawyers, and I want to, and it's not happening here. So I'm going to step back. I called off the motion I had noticed for 2 days ago, and I said, he's going to try to amend some of it. I'm going to get him some stuff, and then we kind of just wanted to restart the deal. So one of the things that you gotta, as big egos as lawyers have, you gotta be humble enough to know when you do go down a road where you're making a mistake or you're stepping on toes, pull back and just correct it, because we all make mistakes. It is what it is.
Yeah, that's true.
All right, let me get another question. Let's do a question. If my kid this is random. If my kid gets hurt using a school's playground equipment, let's say either private school or public school, we can talk about an immunity. What's the does a school have any liability? What if it wasn't negligence and they were just playing? What about for a public playground? What about that? A premises case playground? If you had one of those cases, Debbie, let's start with you.
Yeah, a million of them. There could be liability. Obviously liability always depends on the facts. And the question is, did something go wrong with the playground equipment? Was somebody in on a slide that broke, or was somebody swinging in a swing that broke, or did they fall off monkey bars and get their head hit on the ground, which didn't have anything under it to protect the child? So you have to figure out, what is it that happened? Was there something the school knew or should have known that they could have done to protect the child playing on the playground? Doesn't mean that they are responsible for everything that happens on a playground, for Pete's sake. You could fall off a swing and there's nothing wrong with playground equipment. But you have to first figure out what that is, and then there's a big difference, in my opinion. And I'd like to know what you guys think it is, but I think there's a big difference between private school versus public school, and that is the amount of money you can get on a verdict. If it's a public entity and it falls under the sovereign immunity statutes, and then you can prove that you can make a claim against that public entity if there is a dangerous condition of the property that they had reason to know about. So if it's a slide that, or you're laughing at me, Gary, or a swing that breaks like that and there's no notice, it's going to be very hard to make that claim. And then if you do make that claim and you can get past the initial sovereign immunity limit, then it's capped. Then your recovery is capped because the public entity is protected more than the private entity. What are you laughing at?
It's knew or could have known.
Oh,
not should. Never could have known. I love the could.
I could have known.
And something
I put the word could in my petition, and I blow it up as an exhibit in my closing on the. Sorry, Dave, what were you going to say?
I was going to say, even if you run into the immunity issue with the public school, something that I've been taught and I've learned from my supervisor here, and the approach here is, well, and I think you could take this from a plaintiff's perspective is, well, who manufactured the piece of equipment and what prior incidents does the manufacturer know about? So even though you may not be able to necessarily go after the school, you could look at, well, who services the equipment, and are they, because they may not be part of the school. They could be a separate entity with their own separate policy of insurance. And then the manufacturer of a piece of equipment, certainly you could look at, so we're always looking at risk transfer opportunities. So I think as a plaintiff in that case, even though you may hit a dead end with the school itself, if it's a public entity, it's not the end of the road. And another point, jumping on.
Make your other point, but do you as a defendant look to, you said transfer, tell me, so you're kind of acting as a plaintiff's lawyer too. We're looking who's really at fault here, and is there anybody I can bring in? Sorry, elaborate on that a little bit.
So what we look at, and I've been trained to look at, and this is actually a new set of tools that I did not have in my prior life, and I'm proud to have now, and I think that they are really useful in a variety of circumstances. Is we look at risk transfer, which means what other parties may be at fault or might share fault, and what we do when we look at that is look at the contracts. Is is the school named as an additional insured perhaps on somebody else's policy? Or might they, even if they're not specifically named, might one of the endorsements under an umbrella type clause bring somebody else in? And then we also look at, contractual indemnification as well. So you look at the policies, you look at the contracts, and that's what I mean by risk transfer. Who else can you bring to the party? Who is really at fault? What I've been finding more and more, and I kind of wish I knew this stuff before, was that just because you're insured or your client, if you're the attorney, may be at fault, there may be something that says that even under a circumstance where your client or your insured is at fault, that somebody else needs to pick up the defense and indemnity for them. So I think that is a useful tool both for defense attorneys like Debbie and plaintiff attorneys like you. Who else can you bring to the party? Who else can you rope in? Because that will also bring more dollars to the table and maybe bring the opportunity to bring about resolution once you get the proper parties or additional parties involved. So that's what I mean. And to what I was going to jump in with before was you also have to look at in playground and school settings is what are the ages of the children involved, and also you have to look at supervision. And Debbie was kind of going into this a bit before, but the teachers, you have to look at the counselors that are involved, and also along with risk transfers, who employed those teachers, who employed those counselors, because sometimes there may be other staff members on the playground that are not employed by the school. There may be special aides that are employed by a private company, and there you can get your hook in that way. So there's a lot of dissection that needs to go on early on in the case to your evaluation. So if you're dealing with a public entity, that's not necessarily the end of the road, and there might not necessarily be a cap for all parties involved. So,
anything else on that, Debbie?
No, that's excellent.
Yeah,
I think we're all proud of Dave.
Yeah, Doug, it's great. So what I see too in that is I'll have a case and I'll have, I'll think a certain target defender or whatever. They're trying to bring in these other either someone else who was negligent or a contractual indemnity claim or something, but those people won't play. They won't even answer my lien letters. They just kind of thumb their nose at me, and I have it all the time. And I have people who work for me come up, I've been writing this. They won't answer this. I say, well, you just got to file suit, because sometimes I find that it's the contractual indemnity and who this person worked for and who put down the rubber mat under the swing, and some of this stuff, no one really looks for you. And until you get the power of subpoena, or you put a lawsuit on, then you get everybody's attention a little bit more too. It's like in a snow and ice case. Someone owns the underlying property or fee. Someone is the lessor and has the store. Someone else. You guys know this. Someone else was hired to shovel, and I. No one's gonna. You almost have to file suit in those cases. Dave, if you put other people on notice, like you think someone else is 50% at fault or there's contractual stuff, if they don't listen to you on a claim stage, what do? Do you just tell the plaintiff's lawyer, listen, I've had adjusters call me or lawyers come and say, listen, they're not paying attention to me. I can't tell you anything. We're only going to pay 50% of that. If you want the other 50%, you got to file suit and go after that guy or something.
So what I've learned is if you've got a good argument, it might cost you a little bit more money, but hire outside coverage counsel to write that pushback letter for you. And I think that bringing in coverage counsel brings home your point a little bit better than if it's just the adjuster writing the pushback letter. So I think that helps a lot. It certainly adds to the costs of the case, but in bigger cases, it's worth every penny. So for me, if somebody's not responding back to me and I think I'm right based on the contracts, based on the policies, I'll get somebody to agree with me who's got a JD after their name in the particular jurisdiction, and we'll go toe to toe. I think that I think it's also crucial in those situations where people aren't listening to you. Don't give up. You've got to keep calendaring tasks, to keep following up. You've got to paper not just your file, but their file, and put them, start to put the fear of God in them a little bit too. And you do that by, don't give up. You've got to keep sending those letters. You've got to, don't just give up and just say, oh, this isn't worth another letter. Send another letter. Say, third request, fourth request. And when you put that in highlight, bold, and italics, people will start to notice. And then the next time that their boss or their supervisor looks at the file, that's going to catch somebody else's attention too. And that's really another tool that I kind of earned in my toolbox here is persistence. And part of persistance,
you already used that word.
yeah, perseverance, persistence, and part of that is being organized and knowing when it's time to send out another letter. It's not hard to fire off another letter, but keep it up and bring in outside counsel if you need to. And I think that probably holds true for plaintiffs' lawyers too. Maybe you know a ton about coverage work, Gary, but I'd like to think you may not. And I think it's important for the plaintiffs' lawyers too to bring in a heavy hitter as needed to help explore some of those issues. And so those are my thoughts on that.
Good thoughts. What I taught a CLE question here. What about when how do you so you bring in coverage counsel? What about if you have an insured who you have a reservation of rights for, but you can't get that insured to move off the dime or do anything about it? And because I want to resolve coverage on the plaintiff side, is there any tricks with getting them? I want them to go find somebody to do that, or I've done things where I've tried to get them to get a lawyer or other things. Any tricks with that? Let me start with Debbie on that one.
I'm not telling. I'm not telling the tricks. I'm not telling the tricks. Are you saying how do I? Are you saying how do I get my insured to go get help, or how do you get my insured to go get help?
How do I do it? You're doing your duty to defend, Debbie. You're not going to get into coverage issues, but there's a reservation of rights letter. Is there anything I can do to figure that out? Now, what I've done. I think I always say I would take the position that as a third-party beneficiary, I can file my own deck action. I don't know if do you think I'm going to win that? I've tried to do that. Or do you think I just try it and then figure it out later and take
I think, just remember, even though I can't get involved and represent the insured on coverage issues, if I am defending that insured, I have obligations to that insured. And if you are telling me you want to propose something to the insured, or you want to know the insured's personal attorney, or if you're then I'm going to be trying to get that information.
I write those letters.
Yeah, I think it's important to communicate that. Other people would tell you to offer 537-065 agreement. But of course, in my opinion, unless if there's a reservation of rights, that's fine. But but people are writing and trying to get 537 agreements when there's no reservation of rights, they're going to end up getting zero. Is what they're going to end up doing.
That's right. If you read this, if you read the statute, it's only when there's a declination of coverage. It's not just because the insurance company isn't offering enough.
Exactly right.
That made the case after the end.
It's really annoying when I see those things. But if somebody writes me and says, "Listen, I want to be able to communicate with the attorney for your insured. I'd like to communicate with you about this. Here's what I want." I'm like, I can't do it, but then we'll let the insured know about that and say to the insured, you've got to have counsel on this issue because I can't advise you on this issue. And if somebody's not doing that, then they got to worry about that.
Dave, anything else on that?
I think Debbie covered it pretty well.
All right, let me just jump around some other questions here. So when lawyers get together, is debating each other your favorite party game? So people think that just because lawyers argue for a living, we argue at home. And I find, maybe I did that as a younger person, but I just kind of sit around and I just kind of be quiet more than I used to. I don't know. I just let everybody else want to, I'm a professional. Why bring my professional skills to amateurs?
I think instead of debating, the more fun thing is to share our war stories, which we've been doing offline the couple of days, including Debbie and I talking about our expert depot trips to Maui,
Yeah.
and sharing some of our successes. Um, but yeah, I don't. That's not what we do for fun. No, it's sharing. I think as we get older, it's sharing experiences with our family members, some of our successes at work, but camaraderie. Yeah.
When I share stories around my dinner table, I don't really anymore because, boy, there's no quicker way to get eyes glazed over and no one painted. Hey, let me tell you about blah blah blah. See, I was in a deposition, and then people are like, "What? Like you lost me, and I was in a deposition." No one cares. Um, what do you guys think about the prospect of people in law school now having to do law school virtually, like we are doing this virtually? What's anybody has any 2 cents? I'll share one thing with you. You were Dave was talking about the beginning about life's short and someday. So last week I dropped my oldest kid off at school, college, and their school is doing it right. Tulane has made some national news about doing this. Like you go and you test, and then you got to do a COVID test, and then you have to stay in a hotel for 2 days, and then they let you into the school, and no one can go there. You can't visit dorm to dorm. They have all these rules. It's very robust, and so they're hopeful. But then we hear that UNC opened for a week and then had to close because they had, whatever, 150 cases or 122 or whatever. So, having just gone through, I think that. If people have to do stuff virtually, it's harder with littler kids. I mean, I think it's really tough. Law school, I don't know. I think you could do law school for a semester or two virtually, and it wouldn't affect you that bad. There is something about learning the lawyer's brain, getting the lawyer brain trained in you in that first year, and that critical thinking, and being on the spot, and having doing that whole experience. So you're going to miss some of that, but I mean, and then again, some of that is just hazing. Why do you need to haze people? I don't know. Maybe you don't need to do that. That's my thoughts.
You need
Well,
to haze people because that way they know how to act in a real courtroom when a judge is mean. Although that happens a lot less often than it used to. Dave, what were you saying?
I was going to say, I think that online learning for law school is very possible. I really see, it's opened my eyes, this whole pandemic experience with Zoom, that there's actually lots of opportunities for learning, and you can learn just as well you know, if you focus on the end game. I think that you can learn. For example, if this was a civil procedure class, have the professor talking, and then she can just scroll down with her mouse, and she can click on Debbie Champion and just grill Debbie, but just the same way. So I think
Yeah.
that there's no reason for undergraduate, graduate students, law students not to continue with their goals. I do have some reservations about the bar experience. In taking the actual bar examination, and I had some concerns about that because I do think that environment for taking the bar, it's not just a rite of passage, but I think it keeps everybody on the same level playing ground. And I have some concerns about some of the states that, either said, just like Wisconsin has always done, where if you want to practice in Wisconsin, you don't need to take the bar; you're automatically licensed. What did Missouri end up doing? How did they end up dealing with the bar in the pandemic?
I don't think we have the results back as far as how it went, but I think they set people maybe 8 feet apart, but at least 6 feet apart, and they limited the number of people who could take it to recent graduates, no retakes, and maybe I don't even know if did they let everybody take it, Gary?
I think I just saw an article in the Lawyers Weekly, which I grabbed. They let everybody take it. They had you can see the headline: no reported COVID cases among Missouri bar examinees. So they didn't have anybody. They had everybody test. I think they gave everybody roles. And separated everybody, and people had to do extra questionnaires on symptoms and exposure and what they were doing, the typical stuff. But you put I think as David alluded to, we see different with the corona. We're learning. I've learned a lot of things interesting. Debbie and I talked about how to run a business in a previous podcast, but how institutions and companies are handling it. Some of them are kind of putting their head in the sand and kicking and screaming and stuff. I think that the people that are having success with it are the people that are embracing it, taking it on, figuring out what the change is, having serenity about it. Tulane is a university that did a good job. The Missouri bar, this is the new reality. It ain't just a one-off bar exam. There may be bar exams for years where that's the reality. And so I think companies and businesses that are dealing with it, handling it, doing the appropriate, responsible, systemic change they need to have their company adaptable is a smart course. So we've been going for about an hour. Dave, I have one question. Is your hair, is that Corona hair or is that your regular deal? What are you doing about your hair these days? You've always had good hair.
It's thinning a little bit. I'd hate to show you the upper perspective. I'm trying to go for like the Conan O'Brien deal, and then I've always liked Brendan Walsh from 90210, so I keep the sideburns long and proud. But yeah, I've actually, earlier this summer, I realized that if you follow the precautions and you do what Dr. Fauci and the folks say, that you can live your life for the most part like we used to before. I go to Starbucks every morning. I put my mask on. I sanitize. I have one of those special door opener tools, so I'm not grabbing doors all the time. But yeah, so with my hair, I went and I sucked it up and I started getting my hair cut at the beginning of the summer, and that's the way I've been doing it. Yeah, exactly. That's the tool. Exactly.
I've never seen that.
Yeah, but I've kind of seen that sometimes by fumbling around with it, you have more exposure to surfaces. So what I usually do is just grab a Kleenex, grab the door handle, open it, and then deposit. There you go. Look at that. Burger Law. I love it. Can I get one of those masks, Gary?
Yes. Yeah, you get that. For anybody who wants one of these, message me on Facebook. We're mailing to people. Debbie, I'll give you one. Dave, I'll mail you one. Absolutely.
Will you guys invite me back to participate in this forum again?
It's undecided. At this point, no. I gave my hair. My hair was really long, and then I had an oral argument on Zoom or WebEx or something in the Supreme Court, and I call this the number 6. So I basically shaved my own hair and stuff. But yeah, you learn to figure out what the new normal is. Debbie, when are we going to try another case? When do you think things are going to happen again?
I got an email from, I believe it was Judge Pelican, saying starting September 17th, I think that was the date, we'll be trying trials. So I have a feeling it will not be until after the first of the year for the city, for at least the county. Maybe the city will be earlier than that. But I think the out-state courts are going to start trying cases fairly soon.
Any instinct that you have on that, Dave?
Well, I've got some files down in Florida, and they're going nowhere fast. Same thing in most parts of Texas. I just, for big jury trial cases, I just don't see anything going anytime soon, which is good and bad. I try to make lemonade out of lemons when all possible, and I think it's a really ripe time to do another mediation, do some informal negotiations. So, unfortunately, I don't see any cases being tried in 2020 at this point, given that we're already kind of creeping into fall. And also, the criminal dockets are all backed up too, and you would think that the right to speedy trial is going to take precedence over a slip and fall case for the good and the bad. So, yeah, those are my 2 cents.
Right. Yeah, I agree. I hear you. I agree with you. I had I saw at the beginning of the corona, I saw an uptick on settlements and mediations. Then it kind of petered out a little bit, but I've seen a real uptick again as people are kind of, you know, surrendering to this is the new normal. And I think Debbie, I think you said you had a good point. You're like, well, it's either, and Dave, you talked about cost of defense. It's, yeah, you're not going to get a trial. That may tend to lower your value, but do you want to pay this defense lawyer for the next 6 months or a year to defend the case? I mean, that's part of the deal, right? I Listen, guys, I really appreciate your time today. Thanks for doing it. We've hit a lot of the questions here, Dave. I've really enjoyed talking with you. It's one of the interesting things is how, and Debbie and I have commented on this, is how you kind of go through your path in life and you do years in litigation, and then you meet someone who's kind of come to the same life and practice conclusions, and so it's always reaffirming to hear that and see that.
Well, thanks for having me, guys. I'm really happy we reconnected, and hopefully we can reconnect live over a cup of coffee soon instead of just over a podcast.
And if not, we'll do some podcasts not live and ask you some more details about that trip to Maui.
Right.
Absolutely.
Gary, it's always good to see you. I'll see you next week. But Dave, don't be a stranger.
Yeah. Thanks, everybody. Thanks, everybody.